So what exactly is contingency, and when does our firm offer contingency fee arrangements? First, let's talk about what contingency is. Contingency is when you are paying the services, but you only pay if there's a result at the end of the case. Let's say, for example, your case settles for $100,000 and it's a 40% contingency fee arrangement. You get $60,000, the law firm would get $40,000. That's what a contingency fee arrangement is. Many people want that arrangement because legal services can be expensive, they can be risky, and the law firm takes on the risk that there's going to be a result. Because if there isn't a result, then you don't pay any legal fees associated with it. So I understand why people want that, and we do offer contingency fee arrangements in our firm. But let me describe to you how we do that. So there are generally a couple of characteristics that we look for in a contingency fee arrangement. This isn't absolute. I'm not saying we don't consider cases outside of this range, but this is generally how we look at it. If you've been fired, if you were in the private sector, that means you don't work for a government organization, and if you make over $75,000 a year. Let me talk about each of those and why it is that way. If you've been fired, then you have what we call a very clear adverse employment action, right? You've been fired, you're out of your job. You also now are eligible for lost wages, or the wages you would have earned if you had stayed on at your job and not been treated illegally. In employment law cases, that's often the biggest measure of damages. Yes, you can get some emotional distress. Occasionally you can get punitive damages, but often the biggest paycheck that somebody will get, as in one of our cases, is because you have lost wages. If you haven't been fired, then most times you're not, and you don't have lost wages, you're still getting paid. You may be treating poorly and illegally, you may have a case, but you don't have lost wages. So that's why we look for people who've been fired. Private sector. So if you work for the government, federal government, state government, local governments, very, very rare that we take those cases on contingency, because there are more opportunities for us to help you in those cases procedurally, and because governments generally don't settle. It tends to be more rare than the private sector, and you have to push further into the process to get those settlements because they've got their government lawyers. You know, they're paying them anyway, whether they have to litigate the case or not. So often governments, there's not a lot of incentive certainly to settle early. So for that reason, if you are not in the private sector, you're probably not going to get a contingency fee offer from us. And then the third one is $75,000 in income or over. And again, that is because the biggest measure of damages for these cases is usually lost wages. If you are under $75,000, then it makes it much less economically feasible. I'm not saying impossible, but economically feasible for us to take your case on contingency, because the payout's probably not going to be as big. So if you're in those categories, you've been fired, you don't work for the government, you make over $75,000, then you're in the universe of people that we will usually consider for contingency fee arrangements. Now, then there are a lot of other variables that we looked at even within that pod of cases, you know, the strength of your case, other sources of damages in your case. But nevertheless, if you're in that universe, then you are, in a category that we would consider for contingency. Where might there be exceptions? Generally, it would be if you are still at work and you're being treated, just terribly. Because in order to make that case financially viable for the firm, we have to look at significant emotional distress damages, because again, you don't have lost wages. Now, what if you make less than $75,000 a year? We do take some of those cases on contingency, but here's the difference. For cases under $75,000 a year, we are usually looking for something called fee shifting, which is a type of contingency fee arrangement, the same to you, the client, in the sense that you're not paying unless there's a result at the end. Fee shifting is the defendant, your employer, will pay attorney's fees at the end. So in those sorts of cases, the amount of damages owed to you is not determinative to the firm as to whether or not we'll take the case, because we are looking to get our fees paid by the defendant. And so, for instance, if you have a wage and hour case, let's say the damages to you are $10,000, that's not enough to make it worth to litigate that case in federal court, which can cost many tens of thousands of dollars, could be over $100,000 to litigate that case. Obviously, it doesn't make sense if the pot of money at the end is $10,000 to you. If it's fee shifting, then the firm is counting on getting paid. Let's say the attorney's fees in the case are, so damage are $10,000, but the attorney's fees in the case are $100,000. Well, if the defendant's going to pay that at the end, well, then everybody wins except the defendant, right? So that's a little bit different than just a straight contingency where the firm gets a percentage of the whole pie at the end. So the pie has to be big enough that it makes sense for, that the slice of the pie that comes to the firm is going to cover all the legal services that we provide. So again, that is an exception. If you're under $75,000 and it's a particularly strong case, we may look at fee shifting, but that's generally the exception to the rule. The type of case also affects this. So if you have a contract case, a breach of contract case, if it's a non-compete case or non-solicitation, and those three type of cases usually involve you being either sued by your employer or at least being threatened, your employer's threatening to sue you for those reasons. There's no fee shifting model. Courts don't award fees at the end of those cases. It's not contingency fee because we are here to protect you and your rights, but there's not going to be a payout by the defendant at the end. So in those cases, those are not eligible for contingency, no matter where it doesn't matter if you're with the government or private sector or what you make or whether you're fired or not. So breach of contract, non-compete, non-solicitation, or any kind of case where the defendant is coming after you claiming that you violated some kind of contract with your employer. Those are not eligible for contingency in our firm and in most others.